Hello and welcome to the Minimum Competence episode for Thursday, October 31st, 2024. Happy Halloween. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, the Supreme Court's unexplained decision allowing Virginia to remove voters pre-election, Trump's mail-in ballot lawsuit in Pennsylvania, Musk's court battle over a $1 million voter giveaway, and a legal dispute over a $5.6 billion swipe fee settlement. Let's remember, the Yankees played so poorly they should have lost twice, and read today's legal news. On October 31st, 1864, this day in legal history, Nevada was admitted as the 36th state to the United States, a remarkable feat as the entire Nevada state constitution was sent to Washington, D.C. by Telegraph. This move, a workaround to secure swift approval, resulted in the longest and most costly telegram of its time, spanning over 16,000 words. Nevada's expedited entry into the Union was driven by urgent political motivations. President Abraham Lincoln, up for re-election, sought the state's support for his war policies and the proposed 13th Amendment, which aimed to abolish slavery nationwide. The telegram cost nearly $4,000, a vast sum at the time, equivalent to over $65,000 today, underscoring the importance of Nevada's statehood in the context of the Civil War and the Union's priorities. Nevadans had moved quickly to draft their constitution, striving to meet the requirements for statehood by the October deadline. Officials feared delays from the traditional route of sending documents by train or stagecoach, so they opted for the more reliable telegraph despite the high expense. On the eve of Lincoln's re-election campaign, Nevada's admission helped solidify the Union's stance and reflected Lincoln's strategy to add states sympathetic to his policies. With the telegraphed Constitution, Nevada became a battle-born state, joining the Union at a time when its allegiance to the Union cause was invaluable. The U.S. Supreme Court recently allowed Virginia to remove around 1,600 voters from its rolls just before an election, stirring criticism from voting rights advocates who called it a misuse of the shadow docket. The decision stayed lower court rulings that found Virginia's policy violated federal law by not respecting a required 90-day quiet period before elections, during which systematic voter removals are prohibited. Although the court's conservative majority approved the purge, neither the majority nor dissenting justices explained their reasoning, leaving observers unclear if the decision was based on a legal disagreement or if it was influenced by the Purcell principle, which discourages election-related changes close to voting. The case stemmed from an August executive order by Governor Glenn Youngkin mandating daily voter roll updates based on DMV citizenship data, shifting from a monthly process. Lower courts had sided with the Biden administration and voting groups in blocking this purge, but the Supreme Court's quick, unexplained intervention left little clarity. Critics argue that such opaque, rapid rulings, typical of the shadow docket, are problematic, as they provide no legal guidance and can cause voter confusion, particularly given that such actions seem to contradict the Purcell principle meant to avoid last-minute electoral disruptions. The Trump campaign filed a lawsuit against Bucks County, Pennsylvania, alleging the election officials turned away voters attempting to request mail-in ballots. According to claims circulated by Trump supporters on social media, some voters left empty-handed after waiting in long lines. County officials attributed the issues to a miscommunication and said that people briefly were told they couldn't be accommodated. Pennsylvania Judge Jeffrey G. Trauger granted a preliminary injunction extending the deadline to apply for a mail-in ballot to November 1st, finding that the county's actions violated the state's election code. In Pennsylvania, there is no early in-person voting, but voters can apply for mail-in ballots in person, which led to long lines at Bucks County application sites. The lawsuit, supported by the Republican National Committee, the Pennsylvania GOP, and Senate candidate David McCormick, is part of a broader effort in the key battleground state where polls show close competition between Trump and Kamala Harris. County officials clarified that voters in line by 5 p.m. would be accommodated and assured voters that they could pick up their mail-in ballots later in the week if needed. Elon Musk has been summoned to a Pennsylvania court regarding Philadelphia District Attorney Larry Krasner's attempt to halt Musk's $1 million a day giveaway aimed at registered voters in swing states before the November 5th U.S. election. The giveaway, backed by Musk and America PAC, offers cash to randomly selected individuals who sign a petition supporting free speech and gun rights as long as they are registered voters in key states like Pennsylvania, Georgia, and Wisconsin. Krasner's lawsuit claims the program constitutes an illegal lottery unauthorized by the state and suggests it violates consumer protection laws by allegedly misrepresenting the rules. The legal challenge, set to be addressed by Judge Angelo Foglietta, focuses on state law violations, though legal experts note potential federal implications if the initiative is seen as incentivizing voter registration or influence. Although the U.S. Department of Justice warned Musk's group about possible federal issues, no federal charges have been filed. The initiative has become a major component of Trump's campaign, with Musk providing significant financial backing and voicing public support for the former president. A new lawsuit reveals tensions over legal fee sharing following a massive $5.6 billion settlement in an antitrust case against Visa and MasterCard over credit card swipe fees. Scott & Scott, a law firm involved in the case, is suing co-counsel Robbins Kaplan for allegedly reneging on an agreement to pay Scott & Scott $5 million from its share of the settlement fees, ensuring the firm would receive $20 million. This dispute stems from a 2015 informal fee-sharing agreement tied to another case where Robbins Kaplan received $50 million in fees. Last year, the Second Circuit upheld the $523.2 million attorney fees in the Visa MasterCard case allocated to several law firms involved. However, Scott & Scott claims it was only allocated $15 million by Robbins Geller and that Robbins Kaplan is now refusing to pay the agreed $5 million difference. The case highlights how class action firms sometimes rely on informal agreements to share fees, which are typically not disclosed. Legal experts note that courts prefer to avoid such disputes after approving settlements and fees. Additionally, Scott & Scott's lawsuit may be complicated by the involvement of Patrick Coughlin, an antitrust lawyer who previously worked with Robbins Geller, but later joined Scott & Scott. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, there is no joy in Mudville.